Yeah. As I charge the white. Yeah. Nah, I'm just playing. But look, check it out. It's a reaction video today. We gonna look at Sherone Moore, ex-Michigan Wolverines head football coach, who was fired maybe a couple months ago for stalking his ex and some other things. Well, they fired him for sleeping with the staffer, but come on, let's be real. We all know they just was looking for a reason to get rid of the man anyway. But he appeared in court, and he appeared before the honorable, famous, always viral, honorable Judge Cedric Simpson. So once I say he'll have to go to court before Judge Simpson, bro, I had to do a reaction video because we just got to see what's going on. Judge Simpson has had some epic moments on on the internet, bro.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherone Moore, who is present in court.
Your name, sir?
Sherone Moore.
All right, thank you. Grab my file in back. All right. Take your time set for a probable cause conference. What do we need to do today?
I've had the opportunity to talk with the prosecutor. There is outstanding discovery that we need to have before we can proceed to exam. So we're asking to adjourn the probable cause conference for 30 days to receive that discovery. And the discovery, we're talking about our phone records and Title IX documents.
Okay. Are the people going to be in possession of Title IX documents or have access to those? I guess.
It's a very good question, Your Honor.
Thank
My best understanding.
I usually ask good ones, but go ahead.
This court always does. My best understanding in the moment is that this is not a Title IX investigation per se. My information is coming in real time, as they also say. It was a complaint apparently to the Office of the General Counsel. I have just moments before we came onto the record been informed that there is no written report. That is my best understanding. Whether or not there is some other kind of investigative information that exists has yet to be ferreted out. That effort, that process is ongoing. Ms. Michaels is correct in the aspect of phone records are being sought. All of the, just so the record is clear, all of the evidence and discovery that we have has been furnished to defense, but the investigation is ongoing.
Okay.
Whether or not 30 days is sufficient is a live and good question.
Okay, well, and let me just make sure that I'm clear. Whether 30 days would be sufficient for phone records is questionable, or for everything that Ms. Michaels indicated, I guess.
I believe my thought was everything, but I think that also applies to the phone records. Quite frankly, Judge, I don't know what that timeline is. I can try to find that timeline out and communicate that to the court and counsel, but I don't have that.
Okay, and I guess I'm not, what I don't want to get to, I guess, is a point where we're at a certain point, it may be ready to be set for exam or do whatever, and everything that these records, I'm presuming, Ms. Michaels, that you're saying from the U of M, that are records from the U of M.
Correct. It's our understanding that when you just step back a touch from the actual incident, there were statements made and things done earlier that day to the U of M, statements made by the complaining witness that are going to be important to this investigation because her credibility will always be at issue, and different statements she made to different people will need to be evaluated. So those statements are important.
Okay, I get that, but those, I mean, aren't those documents or statements that you can get on your own, or
That's a great question. I can issue a subpoena if the court is willing to sign a subpoena. I will send a subpoena myself, but I do know based on the police reports that the prosecutor's office is also seeking those documents. And in my experience, documents, people are much more ready to turn over documents to a prosecutor's office than to a defense attorney.
Guess
We may
that's,
quibble about that, but
yeah,
I
it
don't,
depends on one's view of life,
but
but
I take no issue with just starting flowing it through us.
yeah, right. I don't have a problem with that either. It's just, I'm trying to figure out if the request is made. So, because are you attempting to try to obtain those documents?
I am.
Okay. And then once you obtain them, if you do obtain them, you're going to inform counsel or provide them to counsel.
Immediately.
Gotcha.
One more thing, Your Honor, for due diligence sake, maybe I should submit to the court a subpoena for signature. And of course, I'll serve the prosecutor. And I can also submit a subpoena requesting those records, having them returned to the court.
Well, having the results come to the court.
Correct.
Okay, and then we would. Okay, I don't have a problem with that if we're the go-between that it comes here and then goes out. I don't necessarily have that. So unless there's some legal objection to it, if you submit a subpoena to the court, I would sign off on it. I guess try to get this so we can get this thing moving. 30 days. So there's also, and just so that's the discovery issue. Today, I guess that was filed a motion to quash.
That's correct. Earlier today, I, at the court window, filed a motion to quash the arrest warrant and a request for a Frank's hearing. I have a signed copy to tender to the prosecutor, and we will be asking for a hearing date on that motion.
Okay, do you want two separate dates? I mean, how fast do you want? Well, first of all, I mean, the people have to answer. So
Sure.
I guess how fast do you want this?
This can,
And what I'm indicating to you, Michael, is I can set the motion along with the PCC, hear it all at that time. Or I can give you a date for this separate and apart from the PCC.
I would like a date separate and apart. This motion is not determinative of those records. It is prior to those records. So a date to hear this motion prior to receiving those records would be our request.
Right, but I mean, presumably, actually, you're then talking about 3 hearings because there's going to have to be a hearing on the motion to determine whether or not you'd be entitled to a hearing, an evidentiary hearing. Then if necessary, I'd have to set the evidentiary hearing. And then we would also have the PCC.
That is accurate. So a suggestion may be to, whatever the court desires.
Oh, you don't want that. No, go ahead. Okay, that's fine.
You know, this is a lot. So in the expedience, we'll leave it to the court's discretion as to how you want to set things.
That part of it, but we'll try to get through it as quickly and as expeditiously as possible. But the people have seen the motion. How long are you going to need to respond to the motion for the first part of that?
So although I was aware that a motion was filed this morning, I was not served with a copy until moments ago. I have obtained a copy through the court file prior to being at this moment and have had an opportunity to begin to flip through it. I have not consumed it in its entirety. How long to respond was the court's question?
Yes. For the first part of a determination as to whether or not there would even need to be an evidentiary hearing in this case.
Court's pleasure, but at least a week.
At least a week. Okay.
And would you like me to look?
Well, I even have to set it on an off day.
Yeah, I was thinking like a Monday or Tuesday.
On Monday.
21. Yeah. So just tell me how far.
If I give her 10 days. A second, I'm just gonna do her version 10 days. And just give me a week to go through everything, so around this time. Yeah.
It's jury selection.
Here's one.
I think so. We can just move the date.
Got it.
Yeah. One
Okay. Will that work?
Let me make sure. Yes, that.
All right. So with reference to the motion, I'll have the prosecutor's response will be due by maybe longer than a week, February 2nd.
Thank you.
February 2nd, 2026. I will then set this for hearing on the motion. For February 9th,
Let's get 1 p.m.
2026,
Yeah.
At 1 p.m.
Your Honor, may I speak up?
Yes, go ahead.
In the moment, I have a murder case set to start on that date.
That's,
That may change, even within the end of the day today, that may get moved. But in the moment, that is day one of a murder.
that's day one.
That's not a good date for me either, Judge.
You give me a date, and let's see what we can figure out.
Now he asked them what date that they want, and then they said you pick it. Now they saying it's the wrong date. Okay, whatever.
Well, Tuesday the 10th is not going to work if the murder trial goes. So
Tuesday the 17th at 2 o'clock.
Should be fine.
That works for me.
at what time?
2 p.m.
All right. So the motion will be set for February 17, 2026. You said 2
Yes, sir.
at 2 p.m. Okay, and that will be an in-person hearing. We then, in understanding that, depending on the result of that motion, there may be another date that is set. But I'm not going to deal with that at this point because a determination has to be made. So I'll adjourn the probable cause conference. Normally, I'm not really going to care about the date itself, but with all some of the logistics that come along with this case, I have to because of other docketing concerns. Will March 19th then work? I realize that's a little bit longer than what you asked for, but we're going to see each other on the 17th. And then I would adjourn this out to the 19th, hoping that I'll discover at least at that point is clear.
That works for the defense.
Works for me as well. Thank you.
All right. So probable cause conference will be adjourned to March 19th, 2026, 9 a.m. or as your invite indicates. Is there anything else from either side?
Nothing for the.
No, Your Honor.
All right. Thank
you
you
very
very much. Bond will continue.
Thank you.
Thank you.
Man, so from my understanding, what's going on is they set the court date for March 19th, and that's because they got a couple things going on. They filed a motion to find out if they can have an evidentiary hearing, and also the defense want these phone records because they trying to prove that maybe she wasn't stalking my man the way that she was. But I don't know. I ain't no lawyer. That's just my understanding of what I heard. So it looked like this case gonna go out, play out for a while. If they got the probable cause hearing ain't until March, then yeah, this gonna play out all the way through, I say the end of 2026, maybe early 2027. But I don't see this going to trial. I don't see it going to trial. I see him copping out early, somewhere to around the end of the year, bro, so he can go and get back to work. or I could see the case being dismissed, honestly. Because at the end of the day, I feel like they been knew that he was sleeping with this girl, but I know the case ain't really about him sleeping with the girl. It's about what proceeded after that. All of that came out and the things that he did after that. But that firing led to all of this, and they been knew this. They was just looking for the right time to drop it, and not having the best season that he did, you know, that was the time to get rid of him. So let me know what you think, man. That was Sherone Moore appears in court. I'm Big 618Cs, man. Hit that like button, comment, subscribe. If ain't nobody told you they love you, I love you. Peace. Nobody told you they want to see you win. You already know Big 6 want to see you win, man. I'm out.